Good afternoon, everybody. We can start. The COVID-19 has been chasing CPDP 2021 and has been chasing this panel very, very hard. All the movement, we had a number of changes, and actually the panel is affected also today. And so we are online, but our panel is not entirely present. So welcome everybody for Justice 3.0. AI in and for justice and case law as big data challenges. We have the pleasure to be here with a number of colleagues hosted by LEADS, the Legality Attentive Data Scientists Research Project, Horizon 2020, involving 7 universities, 15 ESRs from 4 continents. Some of them are there physically with you, and 8 international partners, including supervising authorities and large companies. We are hosted, and LEADS is hosted by the lab of the Scuola Superiore Sant'Anna, which is an Italian institution, which is pretty much high ranked. But I will not steal that much time for this introducing the institutions hosting. Probably you know it, and the materials in your conference package. So let me tell you something about the panel itself. Unfortunately, Professor Duville cannot join us today. He sent to me a number of remarks. I apologize, but it's absolutely not his fault, as I mentioned before. And we have a challenging panel with Professor Tony from the Imperial College, and with Angelo Dalli from UMNAI, a Maori company in Malta. I will be jumping in as a speaker / reporter speaker as well. Somehow not taking the place of Thibault Duville, but representing somehow the legal component in this panel. We will allocate at least 30 minutes for the discussion, so we do hope, despite the fact that you only see us on screen, we'll be able to engage in this panel and the discussion, because the topics to be discussed are quite a lot and highly interesting, up to the point of being somehow disturbing. So what I will try to do starting is to challenge somehow the panel at large and the people in the room to engage in our topic. Now, as you know, I mean, when in every country we talks in terms of going to the forum. The forum is a Latin word where basically was referring to the market in Roman time. And actually, the first judgments, the first tribunals were held in the forum. And there was a very clear, straightforward reason to have the judgments in public places under the eyes of everybody. This was for every kind of trial, from criminal to civil and commercial trials. Since ancient time, the fact of administering justice in public was guaranteeing basically the transparency of justice and the various principles surrounding that, including various forms of social control. Now, if everything is done in public, clearly we start to have a tension between justice and privacy and data protection, because you might not want to have everyone knowing the reasons for which there has been a breach of contract, or, for instance, just the reasons for which you got a divorce. You might not want to have everybody or just the neighbor closed the door to know why. Now, this basically, from the outset, even before starting to talk into AI, illustrates some potential tensions between the publicity that we need to have for decisions, for case law, and for the privacy of the affected individuals, for which we do have a number of safeguards to be taken, to be put on place. Now, the broad topic, very broad topic of our panel. It's AI in and for justice. What do we mean by that? I mean, the use of intelligent agents, very broadly speaking, just taking on board the last update of the proposed AI Act, intelligent agents, automation to some extent, and now the use of AI to automate and make autonomous decision making has been shaping already justice. I mean, think about the way in which we search in databases case law. But there is not only AI in justice, that is in the administration of justice, the various tools available for attorneys and for judges using various computer-based tools. But there is also AI in a perspective and already in use for justice, for administering justice. So if we start thinking in those terms, it's pretty easy to think about the fact that a number of instances of administration of justice are already automated in a way, and automated up to a point in which the software, whether or not intelligent as it might be, is actually taking the decision for small dispute resolution, small claims. Think about the internet courts in China, but think also in the Western world, in the USA and in Europe, all the automated ways in solving small consumer dispute over and over. So we have AI in justice, in the actual administration of the justice, that is helping attorneys and lawyers, the various search engines, for instance, and the analytics, and for justice, where for justice envisage something more. It envisages the possibility of anticipating a judicial outcome. So AI there, it's potentially or to some extent able to anticipate what would be the outcome of a case, and therefore either be AI in justice, that is instructing, helping attorneys and judges as an assisted automated decision-making tool, or in some cases, potentially and or actually to substitute judge who is adjudicating in a broader sense. Now, I switched from judge to who is adjudicating because we should not think only in terms of administration of justice from a sitting judge. I mean, disputes are somehow decided, allocated, settled eventually by machines also outside. Think about the insurance industry in deciding some allocation of cases and some decisions about cases. So what you see displayed here in the various blocks are just some examples in which AI in and for justice come to the fore, and especially when we take into account the impact they might have on fundamental rights and on data protection, personal data protection. So for instance, all the tools that, for instance, we at Sant'Anna are developing as well, if we have time, we will deal with that later on, in terms of automating pseudonymization / anonymization processes, or in terms of making, by way of using AI developed tools, automatic enrichment of data, extracting from cases directly, not just words or pieces and bytes, but extracting legal arguments. And it's rather clear that all this has a significant impact on case law, at least for one reason. Beyond the boundaries between common law and civil law, law has a shared characteristics. It's not static. It's highly dynamic. Even in civil law countries, the actual operational rule, the rule which is actually applied today in court, and therefore it is taken for granted by parties and potential litigants and economic actors and players, it's a rule that it's different from the one we had before, where before can be yesterday, or it can be years ago, or it can be decades ago, without changing, for instance, the text of statutes. This means that AI, when it is used in a legal environment, when it's used in preparing for the administration of justice or for dealing with legal issues, has to take into account that this is the first strong, if you want, challenge for the colleagues in the panel. It has to take into account this evolutionary pattern of law. And it is difficult, but that's a question also for the panelists, to let an AI learn that some different patterns, one case is not just a deviation, but it's just the seed of change. It's just the starting of a different direction of law. And jurists in the room can think by themselves about a lot of examples. So let me go very, very quickly on a couple of points. AI in data science, broadly speaking, in and for law, has a lot of potentials, while entails also a number of risks. When I speak in terms of risk, I only mean that there are issues we need to deal with and finding solution. So, for instance, while it is absolutely clear that AI can be very extensively used to expand access to law, access to justice in a number of ways, there are just example listed on the left end under potentials, and then can create new strategic tools to improve the efficiency of the administration of justice. We should also take on board all the various risks of uses and abuses, because this means, for instance, depending on who has access to what information, putting undue pressure on, for instance, with adjudicating cases. So the risk is that efficiency can take over on the freedom to allocate and adjudicate cases. It is a clear-cut examples in a comparative fashion. So in some countries, and as my colleague from France would have confirmed, the use of some data for developing predictions, extracting them from cases from the judges, attorneys, and other individuals would be just criminalized, while this is a very well-known service in other countries. And this is, again, a challenge for all of us, because it risks to lead to judge profiling in a good sense, that is, understanding, for instance, which judge has more expertise to cover and cope on specific cases, but also, as I anticipated, might entail some chilling and intimidating effects. Again, this applies as well to attorneys profiling. Anticipating court decision, being able to guess in advance what would be the outcome. Clearly, it's a very good information provided, because this will reduce unnecessary litigation and so on and so forth, improving the administration of justice. But yet, if the AI is not able to get right the possible changes and the arguments, we run a very serious risk of crystallization of law, or even misunderstanding, or even reinforce biases. But I will go very, very quick, because I want first to hear our panelists on all this issue. That is, as I mentioned, the use of case law as material to build AI to be applied both in and for AI has to take into account that the law evolves. So this is creating a number of very differential issues when we apply AI to law. For instance, if it is clear that the risk of automation bias is possible as well in the legal environment, if you compare to health and so on, fields, then we have to take into account the way in which law evolves and the fact that if we cannot definitely put the same kind of explanation about how the prediction has been made in the hands of a lay consumer, an expert attorney, a judge, or just an individual that would like to understand whether or not he or she has a right to be enforced. Now, again, we could keep moving, and I can keep moving in the potentials and risks, but I do not want to preempt the discussion. So I will try to profit of my position as chair, eventually to step in with more and more on these issues also during the various questions. Okay, so at this point, I have very briefly introduced the speakers, and now I need to find how to stop sharing the screen. And I should be able to allow now Professor Tony to intervene with her presentation. Meanwhile, if there are questions you will be asking at the end, please, Francesca, you have.
Can I get going? Can you see my slides?
Yes, you can put in yes. Presentation mode.
I will. Okay, here I am. Thanks a lot, Giovanni, for the most interesting introduction and for organizing this, this panel. It's definitely timely. So I'm going to tell you my kind of point of view over this broad, kind of very broad topic. And my point of view is, of course, that of a computer scientist. So I'm not a lawyer or a legal practitioner. I'm going to start kind of overviewing what, in a sense, we have got in hand, what AI can do for us today. And it can actually do an awful lot. It can play and win games. It can answer queries. It can debate. It can recognize speech, faces. It can translate. It can play, the medic. It can vacuum clean, drive vehicles, and of most interest to this particular panel, it can carry out, as Giovanni already mentioned, few forms of what I would call legal reasoning. And here I've selected a well-known applications that are predicting recidivism with the Compass data set by North Point. And a lot of this, what is currently being supported by AI is actually empowered by a combination of factors, the use of so-called artificial neural networks, or as they are most commonly known today, deep learning, alongside the use of big data that allows to learn in depth, as well as the availability of great computational power that was not available before. So artificial neural networks, as you probably all know, are based on an abstraction of the way human neural networks, the brains, function, and they are highly complex structures whereby very many neurons or small computing entities interact, each computing a function, which could be, for example, one of these mathematical functions, but whose power is emerging from the interactions between the various neurons with their activations. And these kind of structures draw their power from the ability of being trained from large amounts of data, and when they're trained, their parameters are set according to, if you like, statistical patterns drawn from the data, and the data can be varied, could be tabular, graphical, images, text, etc. So this is somewhat the what we've got to do with. And of course, if you throw an awful lot of data to these mathematical entities, you get something which is extremely opaque, or as we say in jargon, a black box. So because of the wide use of these very opaque black boxes to support all the various applications I mentioned before and more, there is a big kind of awareness and understanding that one needs to have a better understanding what they're doing. But before I tell you about that, I wanted to focus in particular on one example of the kind of automated legal reasoning that is being supported. This is an existing challenge which has a very strong legal spin, and is possibly one of the ones that Giovanni was kind of referring to. It's a kind of a competition run by the University of Alberta in Canada and alongside the National Institute of Informatics in Japan. And it boils down to several specific tasks. The first one is one of retrieval of legal cases within a repository of cases. And given a new case, this is about extracting supporting cases that help in deciding the original new case. Another case-based task is that of identifying specific bits of text, specific paragraphs within cases that help decide on a case. And within this particular competition, the available data is drawn from the Federal Court of Canada case law. Two more tasks are studied. One is about and both are about civil law rather than case law. The first kind of involves reading a legal bar exam question and extracting articles from civil code that entail an answer to the legal question. And the second is about defining an entailment relationship, which is really about somewhat paving the way towards administering justice. And in this particular setting, the data is drawn from the Japanese legal bar exams and civil law. So these are kind of examples of the kind of things that we computer scientists are aiming at supporting using with some success the kind of artificial neural networks alongside the data I just mentioned, as described before. So this is, of course, an example of a deployment of AI in a high-stake kind of environment. And if we are thinking of building AI systems that can minimally support kind of delivering justice or actually administering justice, as Giovanni was mentioning, then we need to make sure that the AI is getting it right. And this somewhat brings me to the kind of the main topic of my statement here, which is about the fact that we need explainability. We need for the AI that we deploy for these kind of applications to be explainable, and this is something that is very widely acknowledged, not just by computer scientists such as myself, but by society at large. There are indications in legislation, for example, the GDPR, that we should really aim at transparency, and some interpret some of the articles of GDPR as sanctioning a right to explainability when algorithmic decision making is carried out. There are guidelines, again here I singled out the EU one, for pushing for AI systems that can explain the decisions in a manner that is adapted to the stakeholders concerned. Governments are taking notice. Explainability is definitely strong in the agenda of the UK government's AI sector deal. And also business is taking notice, and finance setting within which I operate and work, and where there is a big overlapping with kind of AI and law, is definitely pushing for explainability regulations, prevent methods that may be powerful to be used if they're not explainable. So there is a broad understanding, if you like, that explainable AI is kind of crucial in these settings, and this is, of course, has been pushed strongly because of the use of these black box AI methods, but in reality, it is dictated by the fact that these black box AI systems are mostly non-trustworthy. So they need explaining, not just because we are curious, but because we really don't kind of trust them. And here I'm kind of giving you 3 examples of what it means that we can't quite trust them. In the first place, they may learn unwanted artifacts in the data. So they may, for example, learn after a lot of training to recognize that a certain sign, road sign, is a stop in this case. And this could be very important when designing autonomous vehicles. But while doing so, they may actually learn artifacts such that there is, some kind of leafy background, or the shape of the sign, or the color of the sign. So if they do learn these artifacts, they may actually get predictions when they're live completely wrong. And in the case of signs with similar color and shape and similar background, they may actually compute something highly undesirable. So this is one of the problems that these AI techniques have. They have, they are often learning what we call artifacts, so they're not robust when they are deployed in reality. Also, they may actually be easily manipulated. An example is that where a certain sign, a stop sign, is manipulated by placing stickers on them in a way that humans won't even notice, and the machine is missing completely what the sign stands for. Although without the stickers, it would kind of produce the correct answer, the system may actually produce the wrong answer when the stickers are applied. So this means that it's kind of easy to manipulate them. And also, and that's something that Giovanni has hinted to as well, they may be highly biased because the data they used to train them may be highly biased. So given 2 individuals that are identical except for one characteristics, in this case gender, they may come up with a completely different outcome in a way which is socially undesirable. So these are 3 strong reasons for why we need to understand what these machines are doing. But in reality, this is something that is important independent of the kind of AI that is being used, and even in so-called interpretable AI systems, in my mind, need explaining. This is an extract from a paper dating back to 1978 on deploying an expert system for some medical decision making, and even at the time there was a clear-cut push towards explanation, because when humans who may not be experts in computing or mathematics or engineering want to use this AI system, they need to be empowered to understand what they are doing, no matter how transparent they are to mathematicians and computer scientists. Okay, so that is, in a sense, a broad motivation for a lot of the work I do, the fact that we need to build explainable systems that are explainable towards humans. Of course, the big question then arises, once we have ascertained that explainability is important, the big question arises as to which form should these explanations really take. Currently, this is a very busy area that of explainable AI. There are lots and lots of approaches, and there is a lot of variety. And here I'm just using Arpeggio's overview of what the explainable solutions mean, and you may want to decide whether you want to explain any model or a particular model, and then there are lots of mathematically defined techniques which are then implemented for providing these explanations. But there are doubts as to whether this is really the right way to go, and in particular, there is a strong push within AI itself that we should be looking more at the social sciences for designing explanations. After all, the social sciences have been looking at how humans explain to one another and what format explanations should take or do take for quite a long time. And given that explanations for these systems need to target humans and humans with different abilities, then it seems a natural step to look at the social sciences for inspiration. So what I am doing in the context of a number of projects is looking at using argumentative abstractions for determining explanations, and in particular using what we call computational argumentation, which is a kind of an implemented form of argumentation methodology for supporting in this particular setting explainable AI. I'm looking at applications in finance as well as in healthcare, and most importantly for this audience, in legal context, including looking at the various tasks I mentioned before. So just to give you a flavor, if I may still have 2 minutes, Giovanni, stop me, please. Otherwise,
you have more than 2 minutes.
Okay, so I can actually go even a bit slower. So the approach we are taking is that of building abstractions for data-driven systems, or just systems on their own, and these abstractions are in the form of debates, where different bits of information that we call arguments are interacting with other bits, and we call them arguments because their interactions are argumentative. So these bits of information may support or attack, we say, or agree or disagree, if you prefer, other bits of information. And these are abstractions that do not provide explanations directly, but can be used as the basis for drawing explanations. And the kind of explanation that we are drawing are interactive, in that they leverage interactions with users and allow for back and forth between users and the system via the argumentative explanation themselves. And this interaction, we envisage, can help improve the system, which I think is particularly important, given that, as Giovanni mentioned, in the legal setting, things are hardly static. There is an evolution of the law and how it is applied, and therefore we believe that the ability for the user to interact with systems by their explanations is crucial to support the evolution of the systems themselves. So there are various types of approaches that are followed in the literature by ourselves and others. You can define systems that are natively argumentative, and then they are extracting the kind of explanation is more direct, but you can also use methods which are post hoc, that they build abstractions of non-argumentative models. And in particular, we deploy the second type of approach with artificial neural networks and deep learning to show how via the explanations, how these methods function and work, and empower users to open a window upon these models, and, as I said, potentially debug them and inject their knowledge within them. I think that I will stop here. I could give you more details if there is time and if there is interest, but I'm happy to do that as a follow-up to questions.
Thank you very much, Francesca, for this thoughtful, clear, and sharp presentation. Let me hand over to Angelo for his introductory presentation, and then we can start to get questions. I have a number of questions for both of you already, and I have a couple of slides because I think we are doing something you might find interesting, Francesca and Angelo. All right, Angelo, you have the floor. Thanks for joining.
Hi, thank you for the panel. It's been very, very interesting also, seeing both your presentation and also of Francesca. This is very interesting, and it happens to be something that I've been working on for the last 3 years, focusing on explainable AI, also exploring how this can be used in real life practical applications. So I'm going to share my screen, and I will go through this a little bit. Let's see. So, okay. This is it. Excellent. So basically, my journey through AI has been quite a long one now. For the last 20 years, I have been building up applications in different fields of AI. And for the first 17 of them, I have been using the black box AI to create machine learning models, to solve practical problems in different industries. And as time went by, I started realizing that deep learning and modern methods have a problem. They have a problem of the lack of explainability. And once you cannot explain something, you cannot trust it. If you cannot predict its behavior, you cannot control it. And you cannot use it to have any decision output that impacts human life. And this is what has been the focus of the last 3 years of research that we've been doing and testing, which is basically the conclusion came, okay, how do you utilize the power of neural methods, of deep learning, and also utilize the power of reasoning? And this is what has attracted and why I end up also having a lot of discussions and arguments with legal professionals, because you need to have both a system that can adapt and also that can take into consideration the more formal logic-driven methods. So what we've been working on is this thing called a Neurosymbolic Architecture. And effectively, what has happened? So we had different generations in AI. The neural kind of generation, which we had, the gold standard statistical accuracy, all based on backpropagation, on differentiation, where people largely relinquish control. You put in a bunch of data, you make sure that you pre-process it, and out comes a model. However, there are some theoretical limitations that cannot be easily overcome. First of all, these methods produce a black box that is generally uninterpretable. And also, it is very difficult to be able to understand the basis for the decision-making process. And as people, we need to understand exactly how a decision is being made from one step after the other. There are also other problems. For example, modern AI does not understand the concept of cause and effect, which obviously in the legal practice is one of the most important fundamental issues of what has caused what we've observed. So the symbolic generation, which came about from a long time, actually, there is a long tradition of research in symbolic systems in AI. But the problem is that there is no way, or at least until we've done this, there was not an easy way of combining both, of making the neural feed into the symbolic and the symbolic feedback into the neural. The symbolic systems obviously have the gold standard for interpretability, because you can generate stuff in symbols, in code, in processes, in diagrams. You can still get that meaning and purpose encoded in as knowledge, as graphs basically, and also assertions that you can put in the system, while he have full control over the system because he can understand it, he can see what is happening, and also understand what is going on. So effectively, we're enabling a new paradigm where we collaborate between human and machine. At the core of what we have done is a breakthrough of the neurosymbolic architecture, and we focused on 6 particular areas. One is correlation plus causation. So a lot of statistical methods are based on the concepts of correlation, of frequency-based analysis of data. And they ignore the fact that we have the cause and effect, the chain of cause and effect. And so have been working a lot on integrating cause and inference, which is exactly what is done in the legal profession. In fact, one of my most interesting examples is working out formally the but-for principles, in fact, on the hypothetical scenario that often arises in a lot of legal cases. The second one is the interpretability, to be having intrinsic explainability rather than having a post hoc method that just guesses what is happening in the model. It actually will tell you while creating the answer exactly what is going on. And I feel this is a very important aspect of interpretable models, that they are intrinsically interpretable and hence intrinsically trustworthy also. The third is the symbolic aspect, basically having humans, enabling humans to be in the loop, to be able to give rules, to be able to give knowledge, even from a model that has seen 0 data, you'll be able to get something useful from it, and also then be able to see what the model has extracted from the data and being able to correct it, being able to give back to it some knowledge injection and transfer. We have focused on rules because we feel that it is something that people easily understand. And once you have something in the form of a rule, you can convert it to lots of different formats that are easy to use, especially, well, and in law, at the end, you can actually translate a lot of it into rules. And what Giovanni has mentioned about the ever-changing interpretation of the law is also very important, because just having a static set of rules without having a way of interpreting those rules according to the proper interpretation brief and context leads to a lot of logical issues, in fact. So that's something that we have recognized as we have been testing and evaluating the systems. The last 2 points is to be able to have it programmable, to be able to have the best of both worlds, to go from the statistics to the symbolic, and from the symbolic back to the statistics, and also to be able to interface with code-based systems, with formal language systems. And I feel that this is very important for those that are more familiar with language rather than rules. This is something that is easier to understand. And finally, the neural net itself. It's kind of, I call it like the substrate upon which everything rests, and having the same power of modern neural nets, but having also lossless explainability. At the heart of all this, we are using something called a hypergraph. So hypergraphs are generalizations of a graph structure in which I have a node, different people, the relationships between them, what is happening, and effectively building upon that core to be able to extract explanations, to be able to extract reasoning. So what is the anatomy of an explanation? We have found that there are still a few major components in an explanation that are present in most explanations. Obviously, the reference to data, then the interactions between the different parts of the data with statistics, cause and effect. If you have things derived from logic, the symbolic relationships, the summary, what is most relevant, what is most important, and what is most appropriate to the particular stakeholder who is also consuming that explanation. Because if I'm producing an explanation for a judge or a doctor, maybe it is going to be different from the explanation that I'm going to give to a client or to a patient, for example. So this is very important, the concept of anchor terms, the concept of having features that are the same data that is displayed in different contexts and different relevance according to the consumer of the explanation. And then obviously the output answer, the prediction, together with its explanation and the justification. How did you actually get that answer? How did you get the explanation? And I think all these ingredients need to be present in explainable AI. And that is what we have been focusing on. So I'm going to soon give a few examples. And basically, what is full interpretability? If a system can tell you exactly how the prediction was made and also how the model works. So we have two types of interpretability, one based on the data and one based on the model, the process. And ideally something that interprets something completely with certainty, that guarantees precision, that guarantees correctness, and also is verifiable. Because again, if you cannot predict the behavior of something, you cannot verify how it works, you cannot trust it, especially in any regulated industry, especially in law, where you are impacting human lives. So we started off with doing statistical analysis tools, just checking the usual plots of different aspects of different features, seeing how they vary, seeing how they interrelate together. And this is something that is actually very useful.
4 minutes,
yeah.
Can you send them?
And so one of the unique features of Neurosymbolic is that it can actually then do a root cause analysis and draw diagrams for you. So this is output actually from the Neurosymbolic system. So if you have, for example, something like income, which is in fact the example that Professor Tony used, is if you have different statuses, for example, if you have like relationship, I have the marital status, I have a particular age, I can get exactly what are the factors that decompose in order to lead to the outcome. And this is something that can structure in a way that people can understand. If you're more familiar with something that is more code-oriented, it can actually write code for you. It can actually write a rule for you and tell you exactly the attributions, how they have been decomposed, what is the importance of each part of a rule. When it comes to bias, also, once you understand how something works, you can actually check for bias. So one of the examples that I like to use, this is from the US Census data. You can see, for example, the main dependencies on the income, and you see gender male is one of the features one of the main features that the model is using. Obviously, this is a model that is see the interactions that you're going out from that particular gender, and then being able to mitigate that bias out. So going bias mitigation is very nuanced, and in general, you need the causal models to be able to do that. Basically, those were a few examples, and I think that the ability of neurosymbolic architectures to solve and also resolve the issue of how do you bring about the modern AI deep learning techniques and tie them together with the more logic, symbolic reasoning methods that are common in law, I think this is the way forward, and that is a major solution that I'm sure is going to power a lot of future legal systems. Thank you.
Thank you very much, Angelo. It's very challenging, the promise of combining various tools to create understandable explanations. Let's see, first of all, if there are already questions or interventions from the floor. Go to the microphone. We don't see you guys, so we can only hear what you say. So please go to the microphone if there is a question. I guess CVDP people are lining you up.
No questions yet.
Is there anyone with a microphone or?
Yes, there is a microphone, but no questions yet.
No questions yet. So let me try to break the ice for you. Just asking to both our speakers, how can we actually, according to your experience and knowledge, really differentiate the explanations in the legal field? And a second question, touching what you both said, what is normally the tools that you have been explaining to us works normally on known biases. So you search for race, you search for gender, so on and so forth. But decisions can be biased from many other ways, which are not yet, at least, envisaged and targeted. Is there any way in which explainability can help to prevent in the legal applications to use undetected biases that might lead, for instance, to just not allow me as a Sicilian to get access to a specific tool just because I'm Sicilian, but it doesn't appear because you don't search for Sicilian on that. Up to you. Who wants to go first? Francesca, Angelo? Ladies first.
Yes, I don't mind. I'm happy to go first and give Angelo a bit of a break since he just presented. Okay, so concerning the first question, which is, whether the way I understood it, Giovanni, is whether one needs to, in what way explainable AI needs to be specialized for supporting legal applications. In what way explanations for, or another way to put it is, can general purpose explanations can be suitably deployed for legal applications, or do we need or would we benefit from bespoke explanations? I do strongly believe that every single applications of AI requires bespoke explanations, because it is really down to the background and the needs and goals of the stakeholders involved that need to consume the explanations. Explainability and interpretability are really the eye of the beholder in my mind. And what you would say to a lawyer may be different from what you would say to a judge, may be different to what you say to a person that is seeking to understand what their legal position would be, and what you should say to these different categories of stakeholders in a legal setting needs to be tailored to their know-how. So for sure, I think as a broad concept, one needs to tailor explanations to the stakeholders involved. In the legal case, I think there is something in a legal explanation setting, there is something more to be said, which is generic, so independently of the stakeholders involved. But one of the main characteristics of legal reasoning to me is the fact that you often, when you take legal decisions, you need to interpret the facts. You need to interpret the law. There are opinions, and there are contradictory sometimes interpretations. And of course, I'm not a lawyer, nor have got any legal background, but the way I understand it, talking to lawyers, is that often alternative interpretations may be suitable, and one is after the one that is most advantageous towards their, to the ends they have. And from that viewpoint, to me, computational argumentation is really important and suitable. And one of the reasons why I'm so interested in legal reasoning is that the fact that as soon as there are conflicts and contradictions and alternative interpretations that may be brought up in a legal context, you need to be able to bring them up in your explanation. And possibly, and here I'm being controversial, Angelo, possibly just a chain of rules that are applying clean and tidy would not suffice. So to me, that's a very strong peculiarity of the legal setting. And I can stop here, or I can answer your second question. I don't know whether we want to, I can try and answer your second question, Giovanni. What do you want?
Well, let's first have a group a tour on that.
Right.
Thanks a lot. Definitely, we have different needs in terms of explanation and also in bias. Angelo, it's to you.
Definitely, and I think that being able to represent conflicting interpretations, being able to have rule systems that are actually flexible enough to handle this, I think is very, very important. And this is in fact something that the neural part brings into play, that you'll be, and yeah, you do sometimes end up with a different conflict. And we have actually tried to find solutions in that to keep it in place, kind of, and even having something that contradicts itself, basically. I think it's important also that we make a distinction between bias and fairness, because obviously, you can have the statistical definition of bias, but there's also this what society thinks is bias, the so-called protected classes, in which we know exactly what features to look for. But then, as Giovanna said, the undetected features, the inadvertent features that you may be biasing against. Obviously, all machine learning involves some form of bias, because otherwise you'll not be able to learn something. So at least, the objective that the AI model is applying has to involve some kind of statistical bias. I think that by being able to use methods, exploratory methods, like the decomposition of attributions of results, I think that's how we will detect the previously unknown biases that you may have. For example, sometimes we do look at large data sets and find certain features that are completely unobvious, which the model is picking up. So that could be then a way of exploring and detecting bias. But of course, being able to label it as unfair or unacceptable then needs that societal judgment, which is a form of bias in itself. The societal bias, like interpretation, can be also seen as a form of bias in the argumentation. And obviously, we see which argument wins at the end. But I think there is a link, in fact, between the two.
Thanks a lot, Angelo. But let me challenge both of you with the clarification. What we normally see in law in modern times is that sometimes non-legal formats are highly relevant to determine how the law changes. So, for instance, medical liability has been changing across the board in many legal systems just upon a very meta-legal reason. That is, it has become so complex that you cannot just blame and find the fault of a medical doctor. And that meta-legal formats has an impact on the various places in which the cases are decided. And places I mean that the facts change in their outcome in that situation. If there is anyone willing to step in from the room, just pick up the microphone and start talking. So we wait. We can interrupt at any moment if there are questions or comments to be done, but we don't want to spare. I don't want to spare this opportunity. I heard some noise, so there is a question, please.
Yeah, so my question is for Francesca, and I was wondering, I've heard some differing opinions, and I was wondering what effects a differentially private model would have on the explainability of the model.
Differentiable?
A differentially private model?
Differentially private model. I'm not so sure, really. Why would you think that? Are you referring to the fact that potentially you may want to include or exclude information in the explanation depending on the privacy level of the receiver of the explanation? Is this what you are worrying about?
So I'm not a technical person, but I've been listening to people talk about differential privacy and the idea that, for instance, if you were querying the model, that you wouldn't be able to, it would be differentially private if you were querying it and you wouldn't be able to understand anything about the data set which trained the model. And so whether this would affect the explainability.
Yes, so yes, because kind of indeed, and it could be that different people have access to different types of data. So there could be, I can use my data, but not your data, for example. So for sure, there is a big question as to what you want to include in your explanations. And that's a further argument for customizing explanations. And at the moment, if you look at the state of the art in explanation, it's very hard to, empower this kind of distinction. So this is a challenge that is not being addressed by many, as far as I know, but it's definitely one that is crucial and that somewhat will require enforcing some filters or some masks, if you like, to provide the correct amount of information. It's also very strongly connected to manipulability, sometimes including information within explanations may allow the receivers of those explanations to understand the functioning of the system and therefore manipulate it or make the system do what they want. Think about getting approval for a loan. So this is also connected to that aspect and not just privacy of data. So it is definitely a very good question and definitely a strong challenge for explainable AI.
In fact,
before giving, sorry, Angelo, before giving you the floor, I would like to expand a moment on the question, because I think that the question also touches upon, from the legal point of view, on the fact that if we have constraints in the secondary use of data, we are talking about law, our minds are judicial cases. And if we have constraints in terms of personal data protection in the secondary use, further use, and we can only use for training strongly pseudonymized, but probably you cannot really anonymize, the question would turn, I mean, if I understand and expand on that question, is what kind of impact you can envisage on the trained models by the fact that we withdraw a number of information. So you might not find out that I was condemned because I am Sicilian because that information has been taken away. So what is the impact of using privacy preserving technologies in the raw materials, so to speak, if I can enlarge? Sorry to interrupt you.
No, it's okay. It's actually a very interesting also point that you mentioned. First of all, I feel that before we can have an end-to-end traceability from the data that has been used to train the model and going all the way to the model, will not be able to achieve things, for example, like the right to be forgotten, to have full data sovereignty over the data providers, so that you can selectively remove parts of the data from the model without having to, reconstruct it or retrain it all. This is something that I think where neurosymbolic models actually show a lot of promise, because you can have that end-to-end trainability. And I think even in things, for example, like in the data preserving applications, like there's this homomorphic encryption, for example, in which where the data and the model has access only to encrypted data, I think that is also showing a lot of promise, because the model will be able to give good results without actually having access to the raw data itself.
Thanks a lot. I think we have time for another question, if there is one from the floor, before giving back to you also, Francesca, to complete your thoughts.
Yeah, hi, I'm Michael Seppig, University of Vienna. I also have a question, and because this is also called AI injustice, right? So it's more of a fundamental nature, and I'm also not a computer scientist, but what was described is sort of resembles a syllogism, right? So we have the facts and we have the law, and then we have the consequences, and I can imagine this can be done via AI and so, but my question is, what about when it comes to balancing decisions and maybe even values? Maybe you have an answer for that as well. Thank you.
Excellent question. If I may step in before leaving you the floor, dear colleagues, just I think that you touched upon the most important issue. I mean, I don't have a straightforward answer for that, because balancing is part of the legal system, the way in which we jurists apply law. But what we can try to do is trying to understand what are the factors, the elements, the formats, the legal formats that actually lead to this balancing of the situation. And in the example I was giving, before, let me go to in full screen modality presentation. Okay, doesn't take it, sorry. Sorry. Can you see my screen?
Yes, if you do it again, it will probably take it.
Okay, let me try it again. No, he doesn't want it. Sorry about that. But just to tell you that we are trying to understand at the legal lab how to extract the arguments and how to locate them. And when we are looking for arguments, we are just looking, for instance, to understand what are exactly those balancing factors, what kind of weight they have, and taking into account their location. That is, whether or not, for instance, the argument that, you know, medicine is today too complex to search for a fault, so we need to move to a more strict liability regime. I mean, trying to find that argument somehow hidden in the logic of the legal arguments is a task which is really a challenging one, but that's the only real meaningful to me way of trying to produce tools which are actually usable and can really enable to avoid those crystallization. And I don't think that, but then I will leave the floor to Angela and Francesca. I don't think basically that we are working, or they are working, in terms of a syllogism in the legal domain, because I mean the syllogism in the legal domain, it's not easily applicable, and because the variables are too many. But I know what is your thoughts on that, Francesca and Angela. Francesca, your microphone is muted.
I said interesting questions, kind of interesting question. I guess in a lot of the work I'm aware of on using some form of machine learning for automating legal reasoning, indeed, the attempt is one of automating, if you like, syllogistic reasoning up to a point, or more kind of broadly reasoning with legal information, be cases or laws, and that's something that is at the moment done as a natural language processing task, without thinking about conceptualizations, etc. Maybe a neurosymbolic approach, such as the one that Angelo and his company are kind of working on, could support a hybrid. But what's important, I guess, concerning your question, at least what I interpret your question to be, is whether one can inject, goals and objectives, what one wants to prove. I mean, if I am defending somebody, I want the somebody to come out well. So I need to conduct reasoning that will achieve a certain goal. So there is an element of selection, and I would say of abduction within the reasoning I conduct, whereby I want to identify hypotheses that help me prove what I want to prove. And that's not something that is massively supported, although in the legal setting, at least at the moment, as far as I know, with the state of the art in AI.
Yes, definitely. And I think that all the main three systems of logic need to be supported. In fact, like both the induction, deduction, and abduction, you need to have a mix of all in order to be able to handle them. Something that we also realize that you need to handle legal reasoning and also other industries is to have the possibility of counterfactual reasoning together with the induction, deduction, and abduction. So this leads you to consider hypothetical statements, leads you to be able to set one or more particular variables to a value and then be able to reason on that. And it's surprisingly common, I think, in legal settings, in fact, that you do need this. And seemingly simple arguments, the underlying logical structure supporting it can be pretty complicated, in fact. I think, Giovanni, you're muted.
Yes, unfortunately, I'm muted. All right. I think we have a few minutes still, a couple of minutes to say, but and if you don't mind, I would just use one of them, one of those minutes to display one more slides, trying to complete the answer to the colleague from Austria, from Vienna. I mean, what is needed? I mean, we might be really still far away from predicting coding in real terms, so anticipating an outcome of a decision in meaningful terms. But certainly we are very close and to do something else, that is to use AI tools to develop different tools for reasoning for lawyers. So for instance, what we are doing in PISA is trying to extract and identify in automated ways sentence types and to find them in specific contexts so that the attorneys, the judge, in investigating the data lake, the database, then semantically, automatically enriched databases, it's able to not only to find the specific kind in natural language word, a concept that it's looking for, but finding also in along with the other surrounding sentences. This means that it is able to immediately understand whether or not that argument has been taken on board, whether or not it has been related to evidentiary issues or procedural ones, and to immediately, even visibly, as I can try to show, to perceive the pattern of the arguments. This doesn't allow to do automatic prediction, but certainly allows to do that kind of analysis and of the balancing that the colleagues was asking before. Having said that, if there are no more questions, I don't think we have time to answer. I would just give 1 minute each to Francesca and Angelo if they want to have some closing remarks and challenge for the audience and for ourselves.
I can start just 1 minute. I think that this kind of discussion is really crucial because it takes into account the the drive of the application in particular. We as computer scientists, of course, we generate generic tools and systems, but it's only when we talk to practitioners we make real progress. So I do hope that several of the members of the audience will be wanting to engage in, or maybe they're already engaging in this kind of research, and that there will be opportunities for joint progress. And thanks for inviting me, Giovanni.
Thanks to you, Francesca. Angelo, you have the final words in the last minutes, and I'm sure that from the audience, people will be contacting you and me if you are interested.
Yes, I think that we're going into an exciting phase in which we'll be able to have AI get out of its black box, being able to utilize, the neural symbolic methods, being able to collaborate fully with the symbolic methods, collaborate fully, seeing its line of reasoning, seeing what kind of legal arguments it may come up with. And I think that it may influence the way that law is interpreted over time, the way that it is interpreted and shown also, and how explanations and arguments are structured, maybe giving them a little bit more formality and also being more data-based. We'll see how it works out, but logic is logic, and at the end, hopefully it will prevail. So looking very forward to seeing the applications and the ramifications of what we are doing in explainability in bringing AI and humans in a hybrid system together.
Thank you very much to both of you, the speakers. I'm sorry for the missing colleagues, and we wish them all the best, but definitely we will have more occasions to deal with this, and maybe in the next CBDP, we will bring more stunning results. Thank you, everybody. Thanks for the audience for attending, and have a nice late afternoon and evening closing CBDP.
Thank you.
Thanks.
Bye.